This hearing opens with a classic courtroom standoff. The defendant insists his constitutional rights were violated, claiming he was denied immediate access to a judge. What sounds powerful at first quickly turns into a lesson in legal reality, as the court breaks down how bond schedules actually work and why due process doesn't mean what he thinks it means. The tension builds as statutes are read aloud, but the judge firmly shuts the argument down.
As a judge pre-setting a bond, if you don't like the bond, you can contest it at your first appearance. But in this case, the bond was set by the automatic bond schedule, allowing the defendant a swift release, and he was released within the same day according to the bond schedule that is preset by a judge. In this case, Judge Rickey is our chief judge and has been for quite some time, and he would set our automated bond schedule for 2022.
Well,
he could set that for OR. He could set that for surety. He set it for surety. Your last word on this, Mr. Kelly.
Well, I would like to object because, she keeps saying that's the law, but she hadn't stated any laws relevant to that matter. She's sidestepping the fact that I wasn't taken to a judge, and she wants to turn it into a bond issue, but it's not a bond issue. That's only secondary. The issue is the fact that I was denied due process of law by not be taken to a judge after I demanded it. KSA 8-2104 says specifically that if I demand it, it has
Quote that again. Quote that. Quote what it says. Don't just paraphrase it, but quote it. Say it. Read it exactly the way it says.
All right. 2901 says, except as provided in subsection 7, when arrest is made in a county where the crime charge is alleged to have been committed, the person arrested shall be taken, not any paperwork is what she stated. It says the person arrested shall be taken without unnecessary delay before a magistrate of the court from which the warrant was issued. If the arrest has been made on probable cause without a warrant, he shall be taken without unnecessary delay before the nearest available magistrate, and a complaint shall be filed there forthwith.
Okay, I'm going to stop you there.
Yes.
Now it's my turn to talk.
Absolutely.
All right. You read that statute, sir, multiple times.
Yes.
Never once did you notice or stop or specify a very key provision, and that is, quote, without unnecessary delay, quote. Now, you interpret that as immediate, that you should go and get the magistrate out of bed or out of a church service or whatever he or she is doing, that it has to be immediate. But unnecessary delay could be the next available court date, the next available date the court is open. And that is what you were provided. You were given a bond that a chief judge had set, and he can set those scheduled bonds, OR or surety, and he set it as surety. So you were given immediate bond, which you took advantage of. You were also brought before the magistrate without a unnecessary delay, the next available date for arraignment or first appearance, as Ms. Gillette referred, and you had that hearing, you had that determination. So that I don't find that you have any violations there of rights or laws, and so I'm going to deny that motion, but you are preserved on appeal. So what is your next issue?
Okay, Judge, thanks for that. My next issue is going to be exigent reasons.
Judge, real quick, just so that he's aware, so it's on the record in case of future appeal. If you look at the next paragraph in 22-2901-2, it says, may use, if no warrant for the arrest of the person is before the magistrate, he can make use of telephonic, telegraphic, or radio communication to ascertain the nature of the charged substance of the warrant that has been issued. If no warrant is issued, a complaint, or if no warrant has been issued at that moment, a complaint shall be filed and a warrant issued in the county where the crime is alleged to have been committed. And the nature of the charge, the substance of the warrant, and the amount of the bond shall be communicated to the magistrate before whom the defendant is in custody. So if he remains in custody, then it's not in person. They can use any means necessary, telephone, radio, telegraphic, any kind of form of sin.
Now the argument shifts and the stakes rise. The defendant pivots to a new claim, accusing the officer of manufacturing an excuse to arrest him. He alleges a knife was intentionally placed back into the vehicle to justify a search. This moment is crucial because it reframes a case from paperwork and procedure to alleged misconduct. You can feel the courtroom energy change as this accusation hangs in the air.
Sending communications to do that. It doesn't say in person.
Right. And that from time to time, as a magistrate, I will get a call about bond. I don't mean to say that that can't happen, but in this case, you were afforded the bond, you made the immediate bond, and then you had a magistrate in-person appearance. So thank you, Ms. Gillette. Now,
Judge, if I may interject, please.
Well, that point is settled. Let's move on to the next one. You were talking about the officer didn't have exigent circumstances to arrest you.
That's correct.
All right.
He pulled me out of the vehicle. I surrendered a knife when I was outside of the vehicle, and he took that knife and he put it back within the vehicle, and then he claimed to use that as his exigent reasoning for officer safety. He planted that knife. That knife was out of the vehicle. He claimed it was a weapon, but yet on the offense report and the arrest report, there was no mention of a weapon, but yet he planted that weapon inside my vehicle after it was already out. I was already in custody, so there was no fear of having anything destroyed, any evidence destroyed. I was not a harm to myself. I was in handcuffs, so therefore I was not a harm to him, and he had no exigent. He created his own exigent reason. So in other words, he broke the law in order to enforce the law.
Okay, so we are, again, for evidentiary purposes, relying on the officer's affidavit. Is that the document you're referring to?
Yes, he stated himself.
Okay. All right. He says on Wednesday, August 10th, 2022, I, Deputy Blake Fisher, working for the Greenwood County Sheriff's Office, was patrolling westbound on U.S. Highway 400 at the approximate 327 mile marker in Greenwood County, Kansas, when I noticed a white Ford F-150 pickup truck also traveling westbound on US 400 at approximately 327 mile marker in Greenwood County, Kansas, bearing an expired Kansas temporary tag of, and then he cites that. So stopping there for a moment. Okay. Oh, and he goes on to say, with the displayed expiration date of 7/22/22. So you're not disputing those facts. You're stipulating that that is correct. He did stop you August 10th because your temporary tag expired 7/22. We're agreeing to that. That's not the issue, right?
No, that's not the issue.
All right. And then he says he noticed the tag was flapping. He ran the temporary tag through his dispatch, and I'm skipping ahead since we have a stipulation to the affidavit. And to get to the part you're concerned about, I turned on my overhead emergency vehicle lights. Once the vehicle was fully stopped, I approached the driver's side window where I was greeted by the driver, Gregory Kelly, informing Kelly with the reasons of my traffic stop. While I was speaking with Kelly, I smelled the odor of marijuana coming from within the vehicle based off my training and experience. I asked Kelly to provide me with his driver's license, current proof of insurance as well, the registration on the vehicle he was driving. Kelly was able to provide me with his driver's license, however, was not able to provide me proof of the current proof of insurance nor the registration of the vehicle. So you're agreeing to all of that part of it, sir. Is that correct?
That is correct so far, yes.
This is where facts start boxing the argument in. The judge walks through the officer's affidavit line by line, locking in the timeline of the traffic stop. The defendant agrees to nearly every detail: the expired tag, the stop, and most importantly, the smell of marijuana. By stipulating to these facts, he unknowingly hands a court the foundation it needs. This calm review quietly shifts momentum away from him.
Okay. All right. So then he was standing at your driver's window, ran your license through dispatch, make sure you didn't have any outstanding warrants. Dispatch later informed me Kelly did have a valid license, didn't have any outstanding warrants. After checking the status of, I'm quoting now, after checking the status of Kelly's driver's license, I requested Kelly exit his vehicle, which he did comply with. As Kelly was exiting his vehicle, Kelly informed me he had a knife on his person. I retrieved a pocket knife off of Kelly's front right hand side pants pocket. I secured the pocket knife within the vehicle Kelly was driving. I then instructed Kelly to place his hands on the front push bumper of my patrol vehicle, which he did comply with. Okay, so how does that fit in with what you were arguing, sir?
If you go to the end of that report,
Okay.
it explains that due to officer safety and the fact that there was a weapon in the vehicle, that he had authority to search at that point.
Okay, well, the next paragraph says, I then performed a pat-down search of Kelly's person for officer safety purposes. As I understand it, he'd already taken the knife off of you and put it back in the car. I then performed a pat-down search of Kelly's person for officer safety purposes. After the pat-down search of Kelly's person was concluded, I secured Kelly in handcuffs before performing a probable cause search of the vehicle. For officer safety purposes, due to there being a knife within the vehicle, and that's what you're in reference to?
Yes, it is, Judge.
And I being the only deputy on the traffic stop. Once Kelly was secured with handcuffs, I provided Kelly with his Miranda rights. I asked Kelly if he understood the Miranda rights. I provided him with, Kelly stated he heard what I was saying, however, was not saying he understood anything. I then informed Kelly I smelled the odor of marijuana coming from within the vehicle he was driving. I informed Kelly I had probable cause to search the vehicle based off of the odor of marijuana. Kelly stated he did not give me consent to search the vehicle. I informed Kelly once again I had probable cause to search the vehicle based off the board or the odor of marijuana. Okay, now is there anything else in the report about the knife or anything else you're wanting to argue at this point, or do you want me to continue?
There are no other mentions of the knife after he used that as his.
All right, now what is it about the knife? Make your argument again about the knife, about what's your argument about the knife? Just make that again, please.
He planted evidence in my vehicle in order to have exigent reasons.
Exigent reasons for your arrest or for the search?
No, for a warrantless search.
Of you or the car?
Of the car.
All right, so you think your argument is he was only searching the car because he found a knife in it?
No,
he was only put in the car?
No, there was no exigent reason listed other than the knife, a knife that he placed in my vehicle. What exigent reasons did he give? He didn't give anything other than the fact that there was a knife in the vehicle, and that was his reason to search.
Okay, I understand your argument. Your response, Ms. Gillette?
Your Honor, the knife has nothing to do with probable cause and exigent circumstances in this case. I think the defendant is confused because, again, this is a law topic. Exigent circumstances is to prevent the destruction of evidence and or things that are going on. The Supreme Court has determined that the odor of raw and or burnt marijuana coming from a vehicle provides probable cause to be able to search that vehicle, as stated in the deputy's affidavit. He smelt the odor of marijuana, and therefore that gave him probable cause to perform a probable cause search of the vehicle. Exigent circumstances say that when it's in a vehicle that is able to move, as in State v. Goff, GOFF 239 Pacific 3rd 467, and that was decided in 2010. There is a long history in the state of Kansas going back to the 70s that allow officers to search vehicles based on probable cause of smelling marijuana. He must have the odor, a reason to have initially stopped the vehicle, and a belief that there is that drug in the vehicle. Once the search begins, it's based on the probable cause of the odor. The exigent circumstances that a vehicle is mobile, the vehicle can be.
This is the heart of the hearing. The defendant argues that probable cause alone isn't enough to search a vehicle without a warrant. The prosecutor dismantles that claim with case law, explaining how vehicle mobility itself creates exigent circumstances. The knife issue fades as marijuana odor takes center stage. The judge delivers a decisive ruling, making it clear that the law is settled and the motion to suppress fails.
Easily taken somewhere else and the evidence disposed of, and that the evidence would be mobile at that point because it's in a vehicle. So exigent circumstance does not mean emergency or officer safety. It's a whole different ballgame. Officer safety is a different thing that allows when someone is going to be arrested or removed from a vehicle and be in close proximity to an officer, that for officer safety, they can pat down the person to make sure there's not weapons on them. In this case, there was a weapon present, which is a knife. It was not pulled or brandished, but officers often secure weapons so that they cannot be used to harm. Since Mr. Kelly was removed from the vehicle and he could already be arrested on misdemeanors that are already occurring, he is removed from the vehicle. The pat down is to make sure there's not weapons. He disclosed he had a knife. The knife was secured in the defendant's vehicle. That also prevents the officer from accidentally leaving it in his car, removing it somehow to a different place where it could be lost or messed with. If the vehicle is going to be towed, then it would be secured and included in a tow inventory. And that way it's in a safe place. Deputy Fisher could have also taken the knife back to his own patrol vehicle and secured it there. If someone is being arrested and removed from a vehicle, they can't take a knife into the jail because that's trafficking contraband. They can't take any other weapon or any other things that would be paraphernalia into the jail. And so later on, there would be another pat down and or strip search of a defendant at the jail. But this is a cursory search of a pat just for officer safety to make sure there's no weapons present. And they find all kinds of weapons and all kinds of things on people. And sometimes they feel like something else. And sometimes they brush through and find a bag full of meth and a bag full of marijuana on people. But when you pat them down gently, you're looking for weapons, anything that can hurt you for officer safety. That officer safety check is apart from exigent circumstances on a vehicle. It's not part of the same thing. However, if an officer is patting someone down because a person is mobile and a person can destroy evidence, and they do find a bulge or something in someone's pocket when they're patting them for officer safety, then that becomes evidence that is found and it can be removed and held as evidence. In this case, no evidence was found on the person of Mr. Kelly. It was found in his vehicle with him, which he had sole control over. The exigent circumstances has nothing to do with the officer safety in the knife. That is purely officer safety in this case. And the pat down of Mr. Kelly, he admitted he had a knife, A quick pat down and put the knife back in the vehicle so it's secure and not within reach of Mr. Kelly is not against the law. It has nothing to do with the exigent circumstances. That would be the odor of marijuana and the belief that there are drugs in the vehicle based on the odor of marijuana. They are two separate, totally different things, which is why the knife is never mentioned again. The knife is not something Mr. Kelly is charged with. It would not be evidence. It is not planted. It is simply secured back in his vehicle for officer safety so he cannot reach it.
Okay, Mr. Kelly, I saw you nodding your head negatively, or not nodding, but moving your head negatively as if you weren't agreeing with what she was saying. Or you want to have the final word on this before I make a ruling?
I do, Judge.
Go ahead,
I think that the prosecutor is confused of the law because she's sitting here talking about probable cause. Probable cause is no excuse to search a vehicle unless you have a warrant. The exigent reason is the only reason that he had cause to search a vehicle, and he didn't list one. So if the knife was not the exigent reason, what was the exigent reason? He didn't list one other than the knife. So we're not here talking about whether he had probable cause. The smell of marijuana might have given him probable cause, but it did not give him authority to search my vehicle without a warrant. Only exigent reasons do, and there's only 3 of them: harm to myself, harm to others, a chance that the evidence might be destroyed. There was no chance of the evidence being destroyed. I was already in custody, so therefore I could not go back to my vehicle. He had already said that he was towing my vehicle because I had no insurance. So what was his hurry? Why didn't he not just take it back to the yard, file for a warrant, and get probable, and therefore he'd have probable cause to search? He listed no exigent reason other than the knife. So therefore, without exigent reason, which he did not list, he had no warrantless probable cause. There was none. He'd already secured the vehicle. He'd already secured me. There was no reason for him to search that vehicle without a warrant.
All right, thank you, Mr. Kelly. The courts have well settled the fact that the nature of the mobility of the car itself creates exigent circumstances. Leaving the car sitting alongside the road could allow someone to tamper with the evidence, whether it be you or someone else. But the courts have made it clear that the exigence exists in the nature of the car and its mobility, and that does, if the officer has probable cause, he can search the car without a warrant, that he doesn't have to get a warrant, leave the car along the road and go get a warrant. And the officer says his probable cause, let's see.
The second paragraph in page 2, Judge.
Yeah, I'll get there. I was looking for the first paragraph where he said he smelled marijuana, and I thought that was in the first paragraph.
It is.
Yeah, second paragraph, first page. The deputy says, at approximately 1828 hours, I turned on my overhead emergency lights on my patrol vehicle, initiating a traffic stop on the vehicle. The vehicle came to a complete stop on US Highway 400 at approximately F75 Road in Greenwood County, Kansas. Once the vehicle was fully stopped, I approached the driver's window where I was greeted by the driver, Gregory Kelly, informing Kelly with the reasons for my traffic stop. While I was speaking with Kelly, I smelled the odor of marijuana coming from within the vehicle based on my training and experience. So traffic stop, smell of marijuana coming from within inside the vehicle. mobility of a vehicle. And then when he did the pat-down search for officer safety and put the knife inside the car, but then he goes on to explain why he searched the car. And then that's the paragraph Ms. Gillette referred to, and that's second paragraph, page 2. Yes. I then informed Kelly I smelled the odor of marijuana coming from within the vehicle he was driving. I informed Kelly I had probable cause to search the vehicle based off the odor of the marijuana. So he wasn't searching the vehicle based on what is alleged in this affidavit that I understand the parties have stipulated to for this hearing. He wasn't searching because of danger to himself, but rather because he believed a crime was being committed, that crime being the possession of marijuana. And therefore, because the courts have established that he can search the car under those circumstances, he alleges he did so. So in response to your motion, I deny the motion to suppress based on lack of probable cause. I find that he did have probable cause, and the possession or the smell of marijuana combined with the fact that it was in a car on a highway did give him an exigency to search it without a warrant.
Thank you for that, Judge. I would like to record to reflect that I object to that.
And your objection is noted for appeal, sir. Your next next item.
Honestly, Judge, other than all the other violations, which are in fact will be held harmless, those were my complaints that I felt were harmful.
All right. Well, certainly thank you for exercising your rights to challenge anything that you felt. And I understand from what you've just said now that all the motions have been satisfied. Well, that's not the right language. They've been addressed and ruled on. I'm sure they're not satisfactory to you because, as you said, you're reserving your right to appeal. But is there any other issue concerning discovery or suppression that you want to address at this time, Mr. Kelly?
Not in those regards. I do have a question about the complaint.
All right, let's look at the complaint.
Well, it's really not about the complaint. My question is, how does that work when you've got, I've got the possession and then I've got the paraphernalia charge against me. How do they separate the other, such as the registration or any other minor? How does that get separated? Do we go to trial, decide the possession, and then come back to trial again and do the registration?
All right. What would happen? They would all go to trial together, and the state would have the burden at trial of presenting evidence on each and every count that she wants a conviction on. You'd have the right to cross-examine her witnesses, challenge her evidence, present evidence on your own if you wanted to, testify on your own if you wanted to. You couldn't be forced to testify or present evidence, and if you just stayed mute, did nothing, the burden would still be on the state, and your silence would not be used against you to determine guilt or innocence. A written set of instructions, written to the jury, this is what you have to find. If you want to find him guilty, you have to find A, B, and C. And if you can't, then you find him not guilty, and it'll go through that on every charge. Okay. So the trial would be, again, on all 4 charges, unless a couple of things. Number one would be that if one of the charges were dismissed by the state, and count 3, the insurance was, or if you wanted to admit any of the charges or plead no contest, then they would be taken out as far as the jury trying to find you guilty of them. That's where you sometimes hear about this word plea bargaining, where you and Ms. Gillette might get together and you might say, look, I know I did this, I'll admit to this. If you want to dismiss that, and she might be willing to work with you in that regard, you might be willing to work with her in that regard. And then you might even, some folks even avoid jury trial by doing that.
Right. Well, how would that be done? Would that be done in a court setting or informally at her office or?
If you want to consult, let's see, Missy, do I still have some time for them to go into a breakout room if they wanted to?
I don't think that that's something I'm prepared to do right now.
Oh, you're not prepared to do it now?
I
Okay.
inquire.
All right. Well, usually they don't like to talk to you if you don't have an attorney unless you've waived your right on the record. And you've told me
Have
several
not.
times that you don't want an attorney and that nobody's making you do that. But I'm thinking I also saw where you filed a document.
Yes,
You
correct.
prepared that, let me see if I can find that. Ms. Gillette, do you know what date he filed that, which one that was? Was that one of those February 14th notices he filed?
Yes, it was.
Additional violations. We already covered that one. Here it is. Notice to the court filed February 14th. I will be, and I quote, I will be appearing as sui juris, which is of my own right, not underlined pro se, as the court is under the presumption of which is of one's own person, which I am not. I am not waiving any rights, such as the right to an attorney, but rather I am upholding my right to counsel. Now, you're going to have to explain that to me, sir, because if you're upholding your right to counsel, that makes me think you're going to go out and get an attorney. So are you representing yourself or not?
I am representing myself as sui juris, and my right to counsel, as stated in the Constitution, does not mean attorney. It means counsel.
Oh, okay.
There's a difference between counsel and attorney. Counsel could be anything, could be an advocate, could be myself, could be my next door neighbor. I'm afforded the right of counsel, and that does not mean attorney. That has been construed throughout history as meaning attorney, but it does not mean attorney. That is how I'm describing that. So
you are upholding your right to obtain counsel, non-legal counsel.
That's correct.
Friends, family, yourself, but you do not want an attorney.
That is correct.
You're waiving your right to attorney, but not to friendly counsel from non-legal sources. Okay. Did I get that right?
I'm not waiving my rights to an attorney. I'm only choosing not to have an attorney. I'm not waiving any rights, Judge. I don't mean to be disrespectful, but I'm not waiving my rights to an attorney. You're trying to box me into something there.
No, I'm not trying to box you in, but we are kind of hung up on semantics, I think. All right, so you're not waiving your right to an attorney, but you don't want an attorney, and you're not going to use an attorney. Is that correct?
That is correct, Judge. And
you're going to proceed on your own behalf without having someone appear for you. You're going to make your own arguments, but if you want to go talk to your friend and have your friend give you non-legal counsel, you'll do that.
But yes.
Okay.
Difference.
I think I understand that. And I think we've made a record of that. But the bottom line is you are voluntarily proceeding without a lawyer today and for future hearings, unless you change your mind.
That is correct, Judge.
All right. Well, I'm still going to have the record reflect that you are knowingly and voluntarily proceeding without an attorney, knowing that you have the right to hire an attorney, and knowing that if you cannot afford an attorney, you can apply for a court-appointed attorney, and if you qualify, one can be appointed.
Yes, Judge, I understood that, and that is correct.
All right. So then, Ms. Gillette, with that statement of record, and he wouldn't sign our standard form. As I recall, you would not sign our standard waiver form when you were in the courthouse, right?
Correct.
That's why you came up with this notice to the court of your own. With that, Ms. Gillette, if he wants to call you and negotiate a plea, do you want to entertain that call, or what would you suggest to him at this point on that issue?
If he wants to call and set up an appointment with my office, that's fine. I'm in court the rest of today with you. So I'll be in court all day. I can't do it today.
That wouldn't be done today.
Okay. All right. So that's how that is done in answer to your original question, that if you want to try to negotiate a plea with her, you call her, you set up a time, and then you make your pitch to her, and she can tell you whether she wants to work with you, and you guys can negotiate that. In the meantime, you're still wanting a jury trial if you can't work it out. Is that right?
That is correct, Judge.
And I don't think, are we set for jury trial in June, Missy? Do we have him on our docket?
We do have him set for a jury trial.
Okay.
I believe it is June. Pre-trial June 12th, jury trial starting June 14th.
Okay. So do you have those dates, sir?
Yes, I do.
Okay. Now, the one when you come in for pretrial,
Yes.
that will be by Zoom on Monday, June 12th.
Okay.
And if you and Miss Gillette before then work out a plea agreement, you can announce it and enter it at that time.
Okay.
If you can't, then we'll plan on the jury trial, but understand it's like before. There are going to be a number of you set at the same time for jury trial. One will go, the others will have to be moved again. Okay. But if the two of you can work something out, great. We can have you enter it at that time.
Thank you, Judge. Appreciate it.
You're welcome. Okay, I don't hear anything else that we need to settle today. Ms. Gillette, does the state have anything we need to resolve or address?
No, Judge, I don't think so.
All right, thank you. Mr. Kelly, anything else we need to address or resolve before we adjourn?
Not in my opinion.
All right, and you know well how to call the county attorney. You've got their number?
Yes.
All right, thank you both very much. We will be adjourned of this case, or I should say we'll be in recess on this case.
All right,
Both
thank
take
you,
out.
Judge.
The final stretch reveals where this case is really headed. The discussion turns to trial procedure, plea negotiations, and the defendant's insistence on representing himself while rejecting an attorney. The judge carefully places everything on the record, ensuring no confusion for appeal. With trial dates set and arguments exhausted, the hearing closes quietly but decisively. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.